Good morning. This discussion concerns relevant evidence. When we discuss relevant evidence, we start with Article 402. Article 402 is the general rule in reference to relevance. It says that all evidence, relevant evidence, is admissible except as otherwise provided by the Constitution of the United States, by the Constitution of Louisiana, this code of evidence, or other legislation. Evidence which is not relevant is not admissible. Basically, what the article says is that only relevant evidence is admissible, with few exceptions that apply to it. Now, in order to determine what relevant evidence is, we have to move to Article 401. Article 401 basically says that relevant evidence is any evidence having any tendency to make a fact, to make the existence of a fact that is a consequence to determination of a case more or less probable than it would be without that particular fact. Now, in order to determine what relevant evidence is, we have to break down that definition. That definition can be broken down into two categories. First, the evidence has to be of consequence to the determination of a case. When we talk about evidence that is of consequence to the determination of a case, basically we want to know how is it related to the particular case. As my grandmother used to tell me, what does this have to do with the price of tea in China? What does it have to do with the case? This is called logical relevance. And is it logically related to the particular case? And if it's logically related to a particular case, it is of consequence to the determination of the case. In order to make that determination as to whether it's of consequence to the determination of a case, the first question that you need to ask is what factual proposition is the evidence being offered? For what factual proposition is the evidence being offered? And in making that determination, and determining what factual proposition is being offered, let's assume that we have a case that is a negligence case. Person runs a stop sign. Wants to introduce evidence that on the day that the accident occurred, that it was sunny, that it was a sunshiny day. So the question becomes: is this relevant to the case? For what factual proposition is being offered? Here, it's being offered for the purpose of showing that the person had a clear view of the stop sign. Is that relevant to the case? In order to determine whether it's logical relevance, you look to the substantive law. The substantive law determines whether something is logically relevant. That is it necessary or is it related to the claim, charge, or defense of the case? Is it related to the claim, charge, or defense? And here we have a civil case. In a civil case, the claim is that the person ran the stop sign and that the day was sunny. Now, is the fact that the day was sunny, is it related to the claim, charge, or defense? And that is it related to the claim? And here it is related to the claim because it goes towards showing that he had a clear view of the sign. There was no weather distortion or anything that would prevent him from seeing the sign in reference to the weather. And thus, it is of consequence to the determination of the case. Now, in order to determine, let me give you a hypothetical and see if you can answer that question, see if you truly understand whether something is of consequence to the determination of the case. Let's assume that A is charged with battery. A is charged with battery of his girlfriend. And not his girlfriend, I'm sorry. A is charged with battery of a female. A walks up to the female, taps her on the shoulder. She turns around and he hits her in the face. His defense is that he thought that this girl was his former girlfriend who had taken his ring and taken his money and had run off with it. And thus, that's why he punched her in the face. Now, he's charged with simple battery. Now, the question is it relevant? He raises this, and he raises the fact that he thought that she was his former girlfriend who had taken his money, who had taken the ring and had run off with it. And he hadn't heard from her any longer, and thus he was angry, he was upset. So the question becomes, is it relevant to the charge of simple battery? Simple battery is the use of force or violence against another without his or her consent. And so his defense is that it was a mistaken identity. He thought that it was his former girlfriend, but it was not. And if it had not been his former girlfriend, he would never hit her. Thus, it's relevant. However, it is not relevant because it is not a defense that is permitted by the law. So you look to the law. You look to the law to make the determination as to whether it is of consequence to the determination of the case. The law here would not allow him to say that I mistakenly thought that you were someone else and thus I hit you. It only requires that you unlawful contact with someone else without that person's consent. And here, there was unlawful contact without consent, and the mistaken identity is not a defense that the law allows. Thus, it's not of consequence to determination of the case. And the second requirement for relevant evidence is that it must have probative value. That is, it must have value to prove the proposition for which it's being offered. So again, we go back and look at for what factual proposition is the evidence being offered. Here, in our case, is being offered for the purposes of proving, going back to the case in reference to the accident, the civil case in reference to the accident where the person ran the stop sign. In our case, the question is whether there was some weather obstruction that would have prevented him from clearly seeing the stop sign. So we said that it's logically relevant. It's logically relevant because it is of consequence to determination of the case. But is it probative? That is, what value does it have to prove that factual proposition for which is being offered? And what happens here, if you go back and you look at the definition of relevance in 401, it says, evidence that has any tendency to make a fact which is of consequence to determination of a case more or less probable than it would be without that evidence. You look at that any tendency actually modifies the second part of the second qualification for evidence, for relevance. That is, whether it has probative value, whether it has value to prove. And it only has to have any tendency to prove. That is, if it tilts the scale ever so slightly in any direction, then it has a tendency to prove the fact that it's a consequence to determination of the case. Now, does it have probative value? Does it have probative value to prove that it was a rainy day or it was not a rainy day on that particular day? Yes, it has. It has probative value to prove that fact which is a consequence of determination of the case, and therefore it is probative. It has value to prove. Now, it does not have to prove the case. It does not have to prove the case. It's only a brick in the wall, and each brick will help build that wall in the particular case to prove the person's offense or to prove his claim. And that's all that is necessary. That's all that's necessary. Again, it has probative value if it has any tendency to prove a fact that is consequence to determination of the case. The definition of relevance is meant to admit evidence. It is meant to admit. The threshold is not a high threshold. It is a threshold that is very low. The question of relevance is a 104A question. That is, it is a preliminary question to be determined by the judge. It's a judge-determined question. The judge determines whether evidence is relevant before he will allow it to go to the jury, and the jury uses it in its deliberation. Now, with that in mind, let me give you a couple of hypotheticals and see how well you can do on determining whether evidence is relevant or not. Give me a moment here, if you will, please. Okay. Let's assume that Sonny is killed at the Church's Fried Chicken. Someone was perpetrating a robbery, and Sonny was killed. Sonny's mother files a wrongful death action against Church's Fried Chicken, and she wants to introduce evidence that Sonny was a good boy. He was a kind boy, well-respected individual. On the issue of loss of affection, love and affection, is the evidence relevant? So we have Sonny that's killed during an armed robbery at Church's Fried Chicken. His mom wants to introduce evidence in reference to Sonny's character. Sonny was a good boy. I love Sonny. He gave me no problems. He was kind. He was a respectful boy. And she wants to introduce it for the purpose of showing loss and affection, basically for damages. And so the question becomes, is it relevant? Tell me what you think. First, you have to determine whether it's of consequence to the determination of the case. Is it of consequence to the determination of the case? That is it logically relevant? Does it have any relation to the case and the fact that she's trying to prove? Now, what is she trying to prove? She's trying to prove that I lost love and affection, the loss of love and affection in order to show damages. Thus, is it logically relevant? I would suggest to you that it is logically relevant. Now, does it have probative value for the purposes, any tendency to prove or disprove the fact that is consequence to the case, the proposition for which is being offered? Yes, it does. The fact that he was a good boy, the fact that he was well respected, the fact that he was a kind boy, the fact that she had no problems with him goes to show that she did love that boy. And thus it has value to prove the fact that she has lost love and affection, some love and affection, and therefore the evidence is relevant. I'll post on the twin page some other hypotheticals dealing with relevant evidence. So I'd like for you to go on and answer those questions on the twin page. And in answering those questions, consider two things. Again, consider, is it a consequence to the determination of the case? Remember, to determine whether it's a consequence to the determination of the case, the law makes that determination. Is it valid for the claim, charge, or defense? Does it have any logical relation to the case? And then you look at the probative value. For what factual proposition is it being offered? Does it have value to prove that factual proposition for which it's being offered? And if it has any value to prove, if it has any tendency, then it will be probative. Again, it doesn't have to prove the case. It only has to have some value to prove the case. So I'd like for you to go on and take a look at the hypotheticals, and they will be under the title relevant hypotheticals. And take a look at them and then determine whether they're relevant or not. The answers will be there also. Good luck to you. Now, the next thing that I want to talk about, and I think I have a little time and we can do this very quickly, is what is called legal relevance. Once we determine that a particular piece of evidence is relevant, it is admissible unless it is excluded. And it's excluded if it doesn't meet, excluded or disallowed, if it doesn't meet the requirement of Article 403. Article 403 basically says, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading of the jury, or by considerations of undue delay or waste of time. Although relevant, evidence may be excluded if its probative value is substantially outweighed by one of the listed categories that the judge is to consider. If it's substantially outweighed. And so what you do and what the judge do, this is a balancing test that the judge engages in order to determine whether he's going to let the evidence in, even though it is relevant. And so what the judge will do, he will look at, yes, the evidence is relevant, but should it be excluded? Because the probative value that it has to prove the factual proposition for which is being offered, is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, a consideration of undue delay or waste of time. These are policy issues. These are policy issues that the judge will look at to make a determination as to whether he's going to exclude the evidence. And the question is the probative value substantially outweighed? Is it substantially outweighed by one of the policy considerations? Now, the purpose of this article, again, is to admit evidence. It's not to exclude evidence, because the probative value has to be substantially outweighed. Let me give you an example. Let's assume that D is accused of robbing a convenience store. He goes in, he sticks the convenience store up. The government wants to introduce evidence that the defendant was poor. Is it relevant? Yes, it's relevant. It goes towards showing, yes, you're correct. It goes towards showing motive. Now, if it goes towards showing motive, should we let this evidence in or should it be excluded? So the judge has to look at it. The judge has to look at it and he has to weigh the value of this particular evidence against the unfair prejudice that it would cause. And unfair prejudice basically deals with whether this will sway the jury based on some issue other than fact within the case, whether it would play on the jury's sentiments, whether it would play on the jury's hearts. And here, because it is so general and because what this says is that all poor people steal, all poor people rob, that this evidence should be excluded. The value of it for the purpose of showing motive is substantially outweighed by the unfair prejudice against the defendant, and thus legally under Article 403 it should be excluded. Thank you very much. Have a good day.